I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. What's happening at the FCC? It's a question we're getting a lot from clients who are following data-related issues. Listeners of this program know that we've been watching the FCC, the Federal Communications Commission, closely. They've been active on a number of data fronts, including things like incident response and data breach notification requirements to cyber trust marks, which we've discussed on past episodes. Now they have reintroduced net neutrality regulations, which is an important development in the digital ecosystem. And in doing so, the FCC has now stepped into US efforts to potentially limit data transfers and access to China and other countries of concern. To discuss these important developments, I've invited two of my colleagues to the podcast. Charles Mathias is a returning guest and a partner in the communications practice. And joining Charles is a new guest, John Castle, a counsel in our communications practice. Charles, John, welcome to the podcast.
Hello.
Hello.
Charles, why don't I start with you? Net neutrality. What is it and why are we talking about it again?
Well, net neutrality is a frequent flyer at the Federal Communications Commission. It's been on the lips of commissioners for maybe 15, almost 20 years. And it stands for the principle that internet service providers, or ISPs, should treat all internet communications equally, offering users and online content providers consistent rates and levels of service, irrespective of their content, their website, their platform, the application, type of equipment, source address, and even now which slice of the network they have. And it's in the news today because at the end of April, the Federal Communications Commission adopted a new round of net neutrality rules, which is the latest attempt to make them stick to communications providers outside of the traditional telephone companies that the FCC traditionally regulates.
So let's pause on that one, because I think that is an important component. Are we now talking about ISPs being regulated by the FCC for the very first time, or are they subject to current FCC requirements?
They are subject to some requirements today, but John, you've looked at this and maybe you have some thoughts.
Sure. So it's not exactly the first time that we are talking about ISPs, but it's not the first time that ISPs are being regulated by the FCC, because we have seen over the past decade plus the FCC sort of waffle back and forth on trying to regulate ISPs, and it's largely been determined by which party is in the White House and by extension which party controls the FCC. Traditionally, when we've had a Democrat in the White House, we've had a Democrat leader, a Democratic chairman, or in this case chairwoman leading the FCC, and they have imposed net neutrality rules. And then when the White House is flipped, so has the chairmanship or the chair position, and under Republican leadership, they have revoked those rules. So we've had this ping-ponging effect. And now with a Democratic majority at the FCC, they've reimposed net neutrality rules. And the way they've done that is by classifying broadband internet access service, the service that internet service providers provide to you and me, as a telecommunications service, which is a term of art in the Communications Act, which means that telecommunication services, or those services that are classified as telecommunication services, are regulated under Title II, which is commonly called like utility style regulation, which really means more burdensome regulations that appear in Title II of the Communications Act. And so that is the hook by which the FCC, or Democratic-led FCCs, attempt to regulate broadband internet access service, or the internet connections that you and I have.
So I'm hearing a couple of really important things that I just wanted to amplify there, John. So one is, it sounds like if we're treating the ISPs, those internet service providers, as regulated entities, are we effectively saying that the entities who are operating as ISPs are treated the same way and regulated the same way with respect to data as the big telecom providers?
Generally, yes. There are some caveats, and the FCC has authority under the Communications Act to forbear or basically say these certain provisions don't exist. And when classifying broadband internet access service as a telecommunications service or a Title II service, the FCC traditionally has and did this round as well, forbear from a number of provisions that still apply to your more traditional telephone providers. But in this latest round, they did not forbear from certain provisions that are particularly important now, given the developing geopolitical situation, specifically with China.
Yeah, I want to get to the geopolitics of this in a moment, but as just we start to round out the net neutrality regulations and the impact, frankly, that they will have, ISPs are the most common way that most Americans are going to be able to gain access to data. And so I guess maybe, Charles, is this a component, or you say that ISPs need to treat all of those consumers equally? Does that mean that there is now a baseline set of requirements with respect to how ISPs would be able to process data? Or what is really driving this from a consumer perspective, such that different administrations have very different takes on whether this should be the law of the land?
Well, it's interesting. At one level, it's very simple. You can't discriminate against different customers or different sources of information, and it'll have to be seen how that plays out. One of the things that the opponents of these new net neutrality rules have pointed out is that in the many years that it's been discussed, and as John said, it's been on again, off again regulation, there hasn't been a hue and cry about problems. Many people say that's because states and other countries have their own net neutrality rules already. And as a practical matter, it doesn't make legal sense anyway for ISPs to discriminate and violate what would be net neutrality rules anyway. So what may actually come into place may already be in effect what's happening in the industry.
So, I mean, that's really interesting. I guess, John, what does it mean not to discriminate with respect to individual consumers?
So in the net neutrality context, it's generally with respect to the data that they are trying to obtain or send across the internet. So three basic rules that are generally associated with the principle of net neutrality are no blocking, no throttling, and no paid prioritization. Now, all three of these rules are subject to network management principles. And so in other words, they're not super hard and fast rules. There is some give and take so long as the reason for blocking, throttling, or prioritizing is based on technical network management purposes and not economic purposes. In other words, the idea is that as the intermediary between you, the user, and the services you want to access across the internet, or the data you want to either have sent to you or you want to send, that shouldn't be subject to the intermediary or ISP's economic interest. They should not be able to monkey with that traffic in order to exploit their position between you and what you want to access. When we talk about discrimination in the net neutrality context, I think we're usually talking about access to the suite of services on the wider internet.
So obviously then would have broad implications, for deploying these rules, given the widespread, nature of the uses of these ISPs. But you had mentioned this has been a set of rules that have been proposed before. I think, Charles, you'd said that this is on the frequent flyer list of certain FCC's interests. And I think we actually had a set of net neutrality rules for a hot minute before they were reversed in the early days of the Trump administration. Is there anything different now about how theirs are being proposed, or perhaps how they're being justified? Or are we just setting ourselves up in a position that whenever there is a change in party leadership in the United States, that we'll go back to no net neutrality rule?
John, I'm curious to know what you think, but each time the FCC has tried, and it goes back to Chairman Powell and the Powell principles, where you treat all traffic equally on a voluntary basis, each time the FCC has adopted rules and they've gone to court, the court has reversed in part and upheld in part. So by now, there's a pretty narrow pathway through which the FCC had to draft this order. And I think it's likely that this time this will withstand court scrutiny. For example, I think it's a pretty well-established principle that the FCC does have the authority to classify ISPs, broadband internet access service, as a Title II service. In other words, to subject it to regulation. I think there will be discussions about the extent of that regulation, but not the fact that they can do it. So I would say, if short of having Congress reverse this as they did the last time, chances are going forward, there will be some kind of net neutrality that would withstand judicial review.
Yeah, I mean, interesting. And John, you had mentioned that there is a geopolitics component of this. Is that also effectively being used to justify the need for these regulations?
Yes, absolutely. So one thing that has sort of changed since the previous iteration of this debate in the early Trump administration is the geopolitical situation with China. We have seen the FCC create and then build on what it calls the covered list, which identifies certain telecommunications service providers as well as equipment manufacturers as national threats. And one thing that the covered list did not cover was internet service until the FCC classified broadband internet access service as a telecommunications service or a Title II service. So what that does is bring in the auspice or brings into play what is called Section 214, which is the authority to provide a telecommunications service in the United States, either on an international basis, so overseas into the United States, or domestically within the United States. And the FCC was very clear in this round that it was not going to forbear from Section 214. In other words, Section 214 would continue to apply to ISPs. And the FCC also made clear that Section 214 authority for those entities on the covered list, they would still be subject to Section 214, and their 214 authority was revoked. It was not being granted as part of a blanket license that applied to other ISPs where the FCC had not adjudged those ISPs to pose a threat to national security. In other words, what this does is it prevents those entities on the covered list from providing broadband internet access service, and the FCC teed up in the order potential future consequences vis-a-vis interconnection. It remains to be seen how that'll play out, but FCC, by virtue of its authority over ISPs, could have some authority over who those ISPs interconnect with, such as these providers on the covered list who are still able to provide, say, backbone services or services deeper within the internet that don't necessarily interface directly with consumers like you and me.
So if I'm getting this right, John, it sounds like importantly, in order for the FCC to have jurisdiction over a Chinese-based ISP, they would need to be labeling them as one of the regulated entities. So in ways that, maybe the ISPs in the United States or elsewhere have resisted in the past, in order for the FCC to exert any types of jurisdiction to address this geopolitical concern, they have to take that step of labeling them as a regulated entity. And then once they have that handle, it's not about throttling data, about discrimination, not about any of those things that Charles was just mentioning of the why they have maybe historically leaned into those issues in the US. But now, because they have the jurisdiction, they're able to limit the entities who are providing ISP services to US-based individuals and perhaps the underlying infrastructure that they can leverage in doing so. Is that right?
That is 100% correct. Yep.
And it's interesting because Chairwoman Rosenworcel has, from day one of her tenure as a commissioner and as the chair of the FCC, leaned into the importance of looking out for national security in the nation's communications networks. And I think it was a very astute move on her part to put national security, to blend it into the net neutrality mix. I think it was probably an attempt to try to make some of the naysayers change their views, but it is certainly not inconsistent with what all the commissioners have been recently trying to do, which is to make sure that our networks are more secure than they have been in the past.
Charles, John, I'm interested in your perspective, perhaps on a kind of different way of thinking about what the import is of these proposed rules. Because if you think about the ISPs as being the gateway through which most Americans get access to their data, and we now have the potential for the FCC to limit almost interoperability between those different gateways, does that create an opportunity or perhaps even an incentive for the FCC to try to address some of the cybersecurity risks that users face in connection with their use of the internet. So to use maybe a more specific example, if the FCC or law enforcement or whoever is identifying a specific threat coming from China, Eastern Europe, Russia, wherever, of a cybersecurity attack going on, can now these rules be used to just turn off the connection such that you're making the ISPs be the first responders in connection with that incident?
Well, I can't speak to necessarily the first responder incident, but with respect to interconnection more broadly, I certainly think that the FCC, from a national security perspective, is looking at internet traffic exchange and looking to assert its authority over ISPs, extended authority a little bit further, a little bit deeper into the internet infrastructure more broadly, and regulate internet traffic exchange with entities on the covered list. Where the line gets drawn, I think is going to be, we're going to have to see how that plays out. I imagine it will be subject to litigation, and it could disrupt the entire ecosystem just by virtue of how these ISPs interconnect with a variety of backbone providers. But the order makes pretty clear that the FCC is looking towards internet traffic exchange and classifying internet traffic exchange itself as a broadband internet access service, insofar as that connection is used to exchange broadband internet access service traffic.
Wholeheartedly agree. I think it's consistent with what many members of the FCC have been worried about for a long time. And I think we will see attempts to do what John has described. I think they want to root out insecure sources of data on the network, and they will use this power combined with court orders and other things, and in partnership with other federal agencies, to try to get at the root of it.
But one thing I would add, and apologies if I didn't make this clear at the outset, is that that's not something that's going to happen necessarily overnight. This order and the rules themselves don't give the FCC the authority to say that right off the bat. This is going to be part of a ongoing developing proceeding that likely would require new rules and thus a new rulemaking where parties would have notice and comment opportunities.
But as we've discussed, if national security is invoked in the context of a rulemaking, it usually makes it much easier to get consensus among the commissioners.
Yeah, and it kind of is at a time where it's a pretty fascinating space of trying to understand how, data is being used as either a shield or a weapon, depending on your perspective, in connection with the ongoing debate and scrutiny that the U.S. and China relationship has undergone. I think you're both, have been thinking about the implications of the executive order that was announced from the Biden administration that would potentially have implications for cross-border data transfers to China through data brokers or through service providers, different technology companies who would have access to bulk amounts of information. Part of that actually then just became law, at least with respect to data brokers under the funding bill for the Ukraine and for Israel. We're seeing, proposed legislation in the pharmaceutical and life sciences space under the Biosecure Act. It's coming from multiple different areas around how to tackle potential foreign access to data. This component, when you target the ISPs, which again are the primary ways that most Americans are going to get access to the internet, and you're now saying that we are going to use this change to try to prevent Chinese access to that data through ISPs, that's a big deal.
It is a big deal. And I think one way to look at it, and John is absolutely right, I think there is a China focus, but it's also a leaky network focus. I mean, there are other bad actors and criminal actors that are wreaking havoc daily on communications networks. And so I think one of the things that you could expect the FCC to explore is how it could go about encouraging ISPs to plug any leaks that they could find in the network. And by that, I mean, could they have an NOI? Could they have institute a proceeding about supply chains that have teeth Could they institute a proceeding about border gateway protocol application? Are there other types of things that networks should be doing in the view of the experts, including NIST, that the FCC might want to look in on? So that's, I think, a real opportunity, again, just to plug holes that are perceived to be across networks across the country.
And that, Charles, I think then cuts into another trend, right, that we see in the data space, in particular the cybersecurity space, and that, there is no shortage today of cybersecurity regulators. It seems as though that everybody wants to do that, given that we don't have one primary regulator, and so why don't we not have 100? And depending on the business that you're in, the industry that you're in, and the regulations that apply to you, it seems as though organizations who are subject to those regulations are getting all sorts of specific requirements now from a cybersecurity perspective. And it sounds like from your perspective, ISPs under this formulation, they're going to have to be very sensitive to future cybersecurity requirements.
Yeah, I would say know what best practices are for your industry, and know your supply chain, and know what you have in your network.
I'm interested in what else is happening with the FCC, because actually I think they've also been in the news, and that they are taking action against organizations who have, specifically telecom providers, who have engaged in the uses of personal data and geolocation data, potentially in violation of those rules. Can you talk a little bit about more what they're doing on the enforcement side, really to show that they're serious?
Sure. The commission just adopted a series of forfeitures or fines against the major mobile providers over, I think it was close to $200 million for illegal use of customer data. And what was interesting about this was that this was adopted before the net neutrality rules were adopted by the commission. And it contained an expansive view of what data is. In the traditional 1930s, think dial-up phone view of what personal data was, it was pretty tightly conscripted, and it was the information about your phone number and the location of the call that you were from which you were making the call, and it was pretty much it. And these companies are accused of having, as I understand it, and it's important to point out that when the Enforcement Bureau does something, you don't get all the details. But as I understand it, these companies are alleged to have, or were found to have, impermissibly shared location data, and we all know that just as a part of its functioning, your mobile device constantly communicates location data to the network. And that is not the traditional sort of location data that has traditionally been protected, but it's an expansive view. And some people were very critical. The Republican commissioners thought that this was significant overreach of commission precedent and authority. But interestingly, I don't think that they said that it was impermissible to try to limit misuse of data. They just said that the Federal Trade Commission ought to do it rather than the Federal Communications Commission. And you see in Congress, you see the American Privacy Rights Act of 2024, which was recently introduced, I think, as a discussion draft. And it specifically puts privacy regulation in the hands of the Federal Trade Commission.
Yeah, which makes sense. I mean, given that they have been the primary regulator at the federal level, at least, of kind of consumer privacy and consumer protection laws. That said, we have a number of other regulators who have gotten into the data related space. Think HIPAA, for example, being enforced by a Office of Civil Rights within the Department of Health and Human Services, not the FTC. So it would be a fascinating space to try to see how that's going. But it sounds like this version of the FCC is not inclined to say that they can't enforce with respect to data. In fact, all signs suggest the opposite, that that they are going to be the lead data and cybersecurity cross-border, the technology regulator for ISPs, telecoms, and anybody else who is subject to their rules.
What good regulator voluntarily gives up their authority to go after problems that they see out there? I think the FCC, you're absolutely right. It's, so they're going to continue to do it. And probably in today's political environment, the privacy legislation may not advance very far in Congress, in this Congress. So the FCC will still be there. There will still be this perceived vacuum. The FCC, I think, wants to keep its authority over communications because they've traditionally done it. But I think if you take a step back, it's the communications now are so much more than just dial-up phones that I think there's a reasonable argument that could be made that you're right. FTC is the expert agency here. And another thing just to think about for people, there's a little back and forth between the FCC, which has disaster outage reporting and network outage reporting, and then CISA, which has promulgated rules for their own outage reporting. How is that going to work? And is this going to mean that you are subject to 3 different reporting regimes if your network goes down? I mean, these are important questions that will need to be worked out.
Yeah, I think every data breach lawyer, cybersecurity lawyer has been struggling with that for some time, and it sounds like it's just going to get worse. In other words, there are, every state and I think every territory has their own version of a data breach notification statute. And on top of that, you layer on the federal versions of these data breach notification obligations, then the contractual notifications, and it sounds like we're just growing in that number. I mean, John, I'm interested in your perspective. I think most listeners here are either not going to come from, representing ISPs, and most of them are not going to come from traditional telecoms, but are also very interested in the data ecosystem space. From your perspective, do the net neutrality regulations have a broader impact than just the ISPs of the world?
The policy debate certainly does. I mean, the broader policy debate as it plays out at the FCC involves end users, by which when the FCC uses that term, they mean, the Netflixes, the Googles of the world. Those are all participants in the rulemaking proceeding. They file comments. They are interested in the outcome of the net neutrality debate overall because it's going to impact how their data is treated and how they interact with their customers on the other end of the network. And so it's really is a debate that impacts the entire internet ecosystem. It's the debate that got me interested in going to law school and becoming a lawyer. It impacts streaming video, streaming music, as well as more anodyne uses of the network like email. And so as an economic debate, I think all the big players within the internet ecosystem see potential revenue streams at issue based on the rules that are in play. And so it is, as a policy matter, certainly something that's going to involve more than ISPs, even if the FCC's jurisdiction really is only going to extend over the ISPs by virtue of the Communications Act's grant of authority.
Yeah. So in other words, you're thinking that the implications here may be that, just the ISPs are going to be formally regulated, but depending on the rules that apply to the ISPs, every website or every online service that needs to be able to connect with end users are going to be implicated. So, an example is if you have 2 different streaming services and one streaming service says, we'll give you ISP this amount of money so that our customers get laser fast streaming, and the other streaming service number 2 doesn't pay that, their customers get choppy streaming services. And so the net neutrality rules, right, are designed to kind of address that dynamic, which you can all imagine, depending on which side of the table you sit on, can have very different perspectives on it.
Yep, 100%. The ISP's position has been it's our network. We expended the money to build it, and how we use that resource and how we allocate bandwidth or whatever is our prerogative. At the ends of the network, your streaming services have said needs to be a level playing field. And as a matter of inciting or encouraging competition, the network should remain neutral. And so that's kind of been the underlying debate over the past decade plus. And until, or as long as the FCC has jurisdiction over this matter and it isn't, say, settled legislatively, it's something you could continue to see play out into the future.
Well, John, Charles, really appreciate your insight and expertise on these issues. My guess is that we'll probably need to have you guys on very shortly, given how many developments there are at the FCC and how strongly they are leaning into data, cybersecurity, cross-border data transfers, all of the hot topics in the data ecosystem. So thank you so much.
You're welcome.
Thanks for having me.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.